Good evening, ladies and gentlemen, and welcome to tonight's debate. My name is Patrick Moritz, and I am the chairman, and Andrea Sherwood is the timekeeper. This debate will be judged by a panel of 3 adjudicators who are Miss France, Miss Boyd-Turner, and Miss Bryant. The topic of this debate is that Australia should not allow the repatriation of ISIS brides and their children. The affirmative team seated to my right is from Immanuel College, and the negative team seated to my left is from Westminster School. The speaking time for this debate is 8 minutes with a double bell at the end of your speaking time. A warning bell will ring once at 7 minutes. A continuous bell will ring 30 seconds after the final bell. Please switch off your mobile phones and other electronic devices. I declare this debate open and I call upon the first affirmative speaker, Sanya Ali.
Good evening, Chair, ladies and gentlemen. The topic for tonight's debate is that Australia should not allow the repatriation of ISIS brides and their children. And as the affirmative team, we believe this statement to be undeniably true. Before we present our team's case and arguments, I will begin by defining the key terms of this topic. We define ISIS, or the Islamic State of Iraq and Syria, following the Australian National Security definition, as a Sunni jihadist terrorist group with an extremist and violent ideology that claims religious authority over all Muslims. We then define ISIS brides and children as all the Australian women who have travelled to ISIS-controlled territory, aware of the potential risks to marry ISIS members and their children who are born into ISIS-held areas. We would like to note that the use of bride and children means that we argue both parties must be repatriated, not one or the other. We define repatriation as a process of returning a person to their country of origin, or more relevantly, citizenship. Finally, we interpret the use of Australia to suggest that this debate concerns Australian society and governing bodies only refers to the Australian society. So, to summarise the topic, Australia's governing bodies should not allow the return of ISIS brides and children to Australia despite their citizenship. Now, to outline our team's case, as a first affirmative speaker, I will present 2 points. Firstly, that the ISIS brides may still hold ISIS ideologies and goals which become damaging to our own Australian society, and that the repatriation of ISIS brides and their children would demonstrate a favourability to ISIS members over real immigrants. A second affirmative speaker will rebut the first negative speaker's arguments and present 2 further points, explaining how the repatriation of ISIS brides sends a negative message domestically and internationally of Australia's stance on ISIS behaviour, and that it would suggest to Australian women that the risks of joining and punishments associated with joining ISIS is reversible. Finally, our third speaker will rebut the negative team's arguments and sum up our team case. Before I begin my arguments, I would like to highlight that the affirmative team is not arguing a moral debate of whether or not ISIS brides and their children ethically deserve to return. We aim to outline the factual, diplomatic, social, political, and legal risks associated with the repatriation of previous ISIS members that proves Australian governing bodies should not allow their return to Australia. Now to my first point. ISIS brides still hold ISIS ideals and goals, which becomes damaging to the Australian population. Even though ISIS's territorial caliphate has collapsed, its ideology remains strong among sympathisers worldwide. This extremist worldview promotes jihad, martyrdom, rejection of state authority, and allegiance to ISIS leadership. Women who willingly travelled to Syria and Iraq to join the group were exposed to its ideology daily. Australia's Foreign Minister Penny Wong noted in her 2020 report that ISIS brides willingly make the choice to travel, even if it's through propaganda or online radicalisation. It's ultimately that woman's choice and the consequences that come with it. Some may have been indoctrinated, others may have knowingly supported it. Either way, their return to Australia raises serious risks. It is important to note that ISIS brides are not simply passive victims. Many travelled fully aware of what the group represented, choosing to marry fighters, raise families within the caliphate, and in some cases actively assist ISIS activities. Chief researcher for ISIS interactions in the USA, Al-Khazraji, discussed that approximately 40% of ISIS brides worked as parole officers, fighters, and prison guards, demonstrating their violent experiences in the end. Middle East correspondent for Australia, Adam Harvey, references Melbourne-born ISIS bride Zehra Duman, who begged for repatriation despite her public Twitter post of her using armed rifle to captions "Catch me if you can" in 2015. Ladies and gentlemen, even despite her ISIS status, as a society, we would place her in prison for gun violence. So why should Australia repatriate her? This demonstrates ISIS brides' involvement in military attacks, labelling them as threats for society. Upon their return, even if they are not carrying weapons, they may pose risks in different ways. For example, they could continue to communicate with radicalised networks abroad, share extremist propaganda, or influence others within their communities. Allowing their return introduces an element of ideological contagion that can spread and destabilise Australian society. We have already seen examples of this risk in practice. A clear case is Mariam Rad, an Australian woman repatriated from Syria in October of 2022. According to Conor Burke's 2024's terrorism report with ABC, she was charged with and pleaded guilty to entering and remaining in the Syrian city of Raqqa, which was declared a terrorist area under ISIS control after her repatriation in 2022. Evidence presented to the court showed text messages in which she expressed her unwillingness to leave the land of the caliphate, revealing her loyalty to ISIS even after being there. This demonstrates that even after repatriation, ISIS brides still display ISIS-based ideology, which presents risk to Australian society. These examples highlight two major risks for Australian society with the repatriation of ISIS brides and their children. First, there is a legal and enforcement risk and burden. Prosecuting offences that occurred overseas is complex, costly, and time-consuming. Every repatriated bride and her children would require close surveillance, stretching police, intelligence, and judicial resources that could otherwise focus on preventing domestic threats. With the litigation process taking anywhere from 6 months to 2 years at the moment, according to Upton Law in 2025, simply put, the repatriation of ISIS brides takes away from Australia's domestic issues, causing a legal burden. Second, there is a security risk itself. Even if the women were not planning attacks, sympathising with or promoting ISIS beliefs, they could still radicalise others, including Australians. Ladies and gentlemen, why should Australia burden the legal and security risk present with repatriation of ISIS brides when history demonstrates their continued allegiance to ISIS ideologies? This then connects to my second point. The repatriation of ISIS brides and their children would demonstrate that Australia prioritises ISIS members over real migrants. Supporting the repatriation of ISIS brides and their children over migrants, such as innocent refugees and asylum seekers, shatters Australia's global image, as my second speaker will expand on, and poses moral and political risks. Immigration officer Katri Yubi notes that over 7,000 migrants are living in detention centres waiting for approval to enter Australia, many refugees like the ISIS brides and children. If migrants from other circumstances see less urgency and resources devoted to their immigration compared to high-profile cases, this can develop resentment, feeling xenophobia, whilst providing an argument that the government's priorities are misaligned with the values that it should uphold. So, Mr. Chairman, ladies and gentlemen, the clear risks associated with national image, security, legal enforcement, and safety of our citizens with factual examples demonstrates that Australia should not allow repatriation of ISIS brides and their children.
I call upon the first negative speaker, Barad Abdullahpur.
Good evening, Mr. Chairman, ladies and gentlemen. The topic for tonight's debate is that Australia should not allow the repatriation of ISIS brides and their children. We, the negative team, stand firmly against this statement. We agree with the definition provided by the affirmative team. Tonight, my case will focus on two central arguments. Firstly, that repatriation is the only way to ensure justice and accountability. And secondly, that the children are Australian citizens, and citizenship creates a duty to protect them. Our second speaker will expand the case by discussing safety, fairness and integrity. And our third speaker will rebut the opposition and summarise our team's position. But first, the first affirmative speaker has tried to tell you that the ISIS brides could spread extremist ideologies in Australia. Well, let me tell you this. Leaving them in camps is far more dangerous. Those environments are breeding grounds for radicalisation, with extremist groups actively recruiting. By repatriating, Australia can separate mothers from children if necessary, place women in de-radicalisation programs and ensure children access to proper education and counselling. Controlled reintegration at home is far less risky than leaving them in radicalised, violent environments where their extremist beliefs only harden. Now, on to my first point. The first reason repatriation is necessary is because it is the only way to ensure justice and accountability. Children should not be punished for the crimes of their parents. According to the Oxford English Dictionary, innocent means not responsible for or directly involved in an event. These children meet that definition exactly. They did not enlist in ISIS, they did not choose the ideology, and they did not fight in the conflict. By refusing to repatriate them, Australia would, in effect, hand down a life sentence for actions they never committed. That is purely unjust. But justice is not only about the children. It also applies to the mothers too. Many of these women may have supported ISIS in some way, but as Australian citizens, the only legitimate way to hold them accountable is under Australian law. Leaving them indefinitely in foreign camps is not accountability, it is avoidance. Justice requires evidence to be presented, trials to be held, and punishments to be determined by courts, not by neglect. Australia already has such strong counter-terrorism legislation in place, such as the Criminal Code Amendment Counter-Terrorism Act, which allows the prosecution of Australians who assisted terrorist groups overseas. Repatriation gives our courts the chance to apply those laws. By contrast, abandoning these women leaves their guilt or innocence permanently unresolved. And think about the message this sends. When Australia refuses to repatriate, we simply imply that some citizens are beyond justice, left in a legal void that undermines the very principle of the rule of law, which says that every citizen is entitled to due progress and process, no matter how serious the accusations against them are. So repatriation is not leniency, it is not forgiveness, it is accountability. It ensures that the children are not punished unfairly and that their mothers face the justice system of their own country. The second reason we support repatriation is because these children are not strangers to our nation. They are Australian citizens. According to the Oxford English Dictionary, citizenship is the position or status of being a citizen of a particular country. By law, these children are as Australian as a child sitting in a classroom in Sydney or Adelaide. Citizenship is not conditional. It does not disappear because of where a child was born or what their parents chose to do. Under the Australian Citizenship Act of 2007, citizenship is acquired by descent of at least one parent as an Australian citizen at the time of the child's birth. That means that children born in Syria or Iraq to Australian parents are still legally Australian citizens from the moment that they are born. This is not symbolic, it is binding law. Their citizenship is equal to that of any child born in Melbourne, Perth or Adelaide. And the numbers show that this is a manageable responsibility. According to government estimates and reports from Save the Children and Human Rights Watch, there are around 40 Australian women and 60 Australian children still in detention camps in northeastern Syria. This is roughly 100 people in total. To put that into perspective, 60 children is fewer than the number of students enrolled in just 2 classrooms at a single Australian primary school. This is not an overwhelming task for a nation with the resources of Australia. In fact, the small size makes it easier for child protective services, the courts, and rehabilitation programs to give each case the attention it needs. And Australia has already shown it can do this. In October of 2022, the Australian government successfully repatriated 4 women and 13 children from Syria. These individuals were placed under immediate monitoring, with children enrolled in schools and women investigated under counter-terrorism laws. The operation was carried out securely, proving that Australia has both the logistical ability and the legal framework to handle such cases. It can be done once, it can be done again. And at a scale this small, it is absolutely achievable. Even the women, these so-called ISIS brides, hold citizenship. That does not mean their actions are excused. It means that they must be held accountable under Australian courts, not abandoned in the indefinite detention without trial. Citizenship guarantees rights, but it also demands responsibility. Repatriation allows for both. Rights for the children and responsibility for the mothers. And think about the precedent we set if we refuse. If Australians can effectively strip away the rights of citizens by abandoning them overseas, what stops the government from doing the same in other cases in the future? Citizenship must mean something. It must guarantee protection, due process, and justice. Otherwise, it is simply hollow. So, in conclusion, ladies and gentlemen, our case has shown why repatriation must happen. We have shown that children are innocent, and it is unjust to punish them for circumstances beyond their control. Repatriation is the only way to ensure they are treated fairly. We have also shown that mothers are Australian citizens too, and as such must be dealt with under Australian law. Repatriation ensures that they can be investigated, prosecuted, or rehabilitated here, rather than left in legal limbo with no justice served. A nation that values citizenship and justice cannot abandon its own. That is why we, the Negative Team, support repatriation. Thank you.
I call upon the second affirmative speaker, Amber Harris.
Good evening, Mr. Chairman, ladies and gentlemen. The topic for tonight's debate is that Australia should not allow the repatriation of ISIS brides and their children. We, the affirmative team, strongly believe this statement is true. Our first speaker has already stated that through their potential extremist ideologies, ISIS brides hold a threat to Australian society, and that our priority should be innocent migrants instead of past ISIS members. Today, I'll be speaking to you about 2 points. The first is that allowing repatriation of ISIS brides and their children does not discourage future potential ISIS brides from choosing the same path. And my second point is that supporting past ISIS members could strain international relationships. Now on to my rebuttal. The first speaker from the Negative Team has tried to tell you that the children are innocent and therefore should be brought back to Australia. First of all, the children may be innocent, but that doesn't mean they haven't been raised with an extreme and dangerous ideology, which could put Australia at risk, bringing potential future ISIS extremists into the country. Secondly, our topic stipulates that Australia should not allow the repatriation of ISIS brides and their children, not either or. So if it's too dangerous to bring ISIS brides back into Australia, which Sanya and I have and will explain that it is, then due to the nature of the topic, neither can be repatriated. The first speaker from the Negative Team has also tried to tell you that with rehabilitation, ISIS brides can reintegrate into society and their children. However, a 2021 research study by the National Library of Medicine has found differently, with the conclusion being, we were struck by how many of the former extremists with whom we spoke felt drawn back to radical ideological thoughts and longed for re-engagement with the movements that they left. This proves that at no point can we feel entirely comfortable allowing ISIS brides and their children back into society, as there is no guarantee that they will not fall back into their extreme ideologies, which risks the safety of the entire nation. Now on to my points. My first point is that allowing ISIS brides and children into Australia sends the message that there aren't serious consequences to joining terrorist groups. The terrorist organisation of ISIS has caused the deaths, injuries, kidnapping, slavery, rapes, and tortures of tens of thousands of human beings and committed multiple war crimes, according to the Global Justice Centre. As our first speaker has already highlighted, these ISIS brides made the active decision to leave their safe home country of Australia to aid the efforts of a terrorist organisation. In fact, a lot of them believed they were going to be more closely involved in the violent war efforts than they actually were, as affirmed by Georgetown Institute for Women, Peace and Security, who said, "Women recruited by the Islamic State often think they will be helping with the front-line duties. They are, in fact, being used to solve the fighters' marriage crisis, and are largely confined to domestic chores such as cooking, cleaning and child-rearing." So now, today, unfortunately for ISIS and fortunately for the rest of the world, according to uscongress.gov, while remaining the world's largest Islamic terrorist organisation, ISIS has suffered major setbacks, particularly after 2019, where it experienced a significant defeat with the collapse of their territorial caliphate in eastern Syria after the US-backed Syrian Democratic Forces captured their last stronghold, further punctuated by the killing of the ISIS leader. Because of this defeat, ISIS brides ended up in detention camps, mostly in Syria, where they are held today. So these women have now claimed that they are repentant after the major defeat of ISIS. If Australia were to allow these brides and their children back into Australia, it communicates that they are willing to tolerate support for terrorist organisations. This is deeply detrimental because, say, if in several years from now ISIS makes a resurgence, because remember, they weren't permanently defeated, and they make the same call for more brides, then young impressionable women will see that the best case scenario is that they live out their lives assisting ISIS, and worst case scenario is that they just go back home if things go badly for them, as long as they feign repentance. So why wouldn't they make the same choice that the current ISIS brides have made? And at this stage, if the ISIS brides were repatriated, there is no evidence that they would even be incarcerated. In fact, a real example of this is Mariam Rad, who was repatriated into Australia and pleaded guilty to the charge of willingly entering Syria to be with her Islamic State fighter husband. Despite pleading guilty, she experienced no incarceration. She claimed that she was unaware of her husband's role in ISIS, despite having sent text messages to family members while in Syria, declaring that she would never leave and that she cannot leave the land of the caliphate. These messages, when looked at alongside her 2 attempts at entering Syria, showed that Rad had likely held views favourable to ISIS. The specific crime she committed is under Section 119.2 of the Australian Criminal Code Act, which criminalises Australian citizens entering or remaining in a foreign area declared by the Minister of Foreign Affairs to be a danger zone due to hostile activities by a listed terrorist organisation. So, despite very clearly breaking this law, Mariam was able to move to and assist a terrorist organisation, and then when that went poorly for her, she was allowed back into Australia with no prison time. If the Australian government wishes to prevent the migration of women to ISIS, they have to take a strong, firm stand against anything associated with ISIS. So, while it is unfortunate that 30 to 40 women and their children are forced to live in poor conditions in displacement camps due to the choices they made, we should also consider the tens of thousands of people who were tortured, killed and raped by ISIS, as well as the 27 million Australian citizens that haven't chosen to leave the country to aid a terrorist organisation. If Australia wants to inhibit any future women and their children from choosing to place themselves into this circumstance, they must not allow the repatriation of ISIS brides and their children. My second point is that allowing the repatriation of ISIS brides and their children will be seen as a betrayal of national values to international allies. Our first speaker has already pointed out that should the Australian government actively go out of our way to support those involved with ISIS, this could spark mistrust within citizens, as they may feel leaders are prioritising terrorist rights over national safety and other innocent asylum seekers. But allowing the repatriation of these brides and children will not only damage domestic relations, it will also impact international ones. Firstly, according to RAND, a non-profit research organisation, the US military and its coalition partners played a vital role in the defeat of ISIS, primarily contributing critical air power to combat operations. The US has been heavily involved in the war on ISIS, so imagine the impact it would have if Australia completely undermined the money, resources and men that America sacrificed and prioritised active participants on the other side of the war instead. America has one of the most powerful defence systems in the world, and our alliance with them is considered an anchor for peace and stability around the world by the US Embassy Department. Another vital ally of Australia's is the UK, which has taken a firm stance against ISIS, also playing a vital role in its defeat, as well as firmly barring any ISIS brides from re-entering the country. Does Australia really want to be seen as the lenient country in regard to terrorism in comparison to some of the most powerful countries in the world? Should we really risk straining international relationships with powerful alliances to cover the poor decisions of these women? I think not. In conclusion, ladies and gentlemen, not only does the repatriation of ISIS brides and children potentially encourage other women to follow suit, but it puts vital international relationships at risk. If Australia does not want this unpleasant situation to occur again, or to appear lenient in the face of terrorism, then we must take a firm, unwavering stance against repatriation. Thank you.
I call upon the second negative speaker, Anya Suru.
Good evening, Mr. Chairman, ladies and gentlemen. The topic for our debate this evening is that Australia should not allow the repatriation of ISIS brides and their children, which we, the negative team, firmly disagree with. The first affirmative speaker has stated that those repatriated may still hold ISIS views which can be damaging to society. She gives evidence of select women posting images, brandishing weapons, but fails to acknowledge independent reports from the Human Rights Watch stating that detainees, including children, are held in life-threatening, degrading conditions that may amount to torture with deaths from preventable diseases, violence and neglect. What does that mean? It means that they are in environments where radical ideologies thrive, overcrowded, unstable, and are still infiltrated by ISIS remnants. Imagine leaving vulnerable, traumatised children in a setting where extremists are actively preaching daily. What outcome can we expect, other than deeper radicalisation? By keeping them in these camps, we are not avoiding threat, we are fueling it. In contrast, bringing them back to Australia means we can monitor, prosecute and de-radicalise under our laws and institutions, which I will further discuss in my argument. The affirmative so-called safety strategy is actually a recipe for future violence. The affirmative has claimed that refusing repatriation sends a negative message nationally. In reality, it makes us look irresponsible. International partners expect Australia to uphold human rights and global security standards. Abandonment damages our credibility as a reliable ally and undermines our influence in global counter-terrorism corporations. Strength is shown by taking responsibility, not by running from it. Our first speaker has highlighted that children of ISIS brides are innocent victims who had no choice in being born or taken into conflict zones. Furthermore, he argued that conditions in camps such as Al-Hol are hellish and life-threatening, with extreme risks such as disease and malnutrition. Now, onto my first argument. The security not only of women and children in these camps, but also of Australians at home. This is not a side issue. It is the heart of our responsibility. Right now, Australian women and children are trapped in Al Hol and Rorge camps, which are not just unstable, but incubators for extremism. The International Crisis Group warns Al Hol is a breeding ground for the next generation of ISIS, holding over 50,000 detainees, thousands of them just children. Every day these camps exist, terrorism is allowed to regenerate. Human Rights Watch calls them pressure cookers for extremism. Children are not merely vulnerable, they are actively indoctrinated. Women face violence, hunger, and disease. And Australia is not just failing to act, it is abandoning its citizens. That is not negligence, it is a breach of international law. The Fourth Geneva Convention prohibits collective punishment, yet that is exactly what is happening in these camps. These people are being detained indefinitely, without charge or trial, not for their actions, but for their bloodlines. Over 70% of the children are under 12. A recent 2023 report by Save the Children found that nearly 80 children have died in Al Hol in a single year in 2024 from preventable causes such as malnutrition, hypothermia, and untreated illness. This report emphasises that leaving children in these conditions is not neutral. It is an active choice that deepens trauma and heightens the risk of radicalisation. In fact, humanitarian groups have warned that the longer children remain there, the harder rehabilitation becomes, making the security threat to Australia even greater. The United Nations OCHA warns that they have no schooling, no safety, and no future beyond radicalisation. And let's be absolutely clear, leaving them there does not protect Australians, it endangers us. Counter-terrorism expert Professor Greg Barton warns that these camps, not containing the threat, they are multiplying it. So, the choice is stark. Repatriation gives us control, oversight and accountability. Abandonment gives us instability, radicalisation and risk. Now, on to my second argument, on international precedent. Australia is not the first nation to confront this issue, and experience of other countries provide clear evidence that repatriation can be conducted safely and effectively. Germany, France, and the United States have all repatriated citizens, including women and children, associated with ISIS. But crucially, they've done so over strict legal oversight, security monitoring, and rehabilitation frameworks. For example, France has repatriated over 100 women and children since 2019, placing them immediately under judicial supervision and protective measures. Germany has implemented structured de-radicalisation programs that combine psychological support, education, and social reintegration. A 2021 study by the German Federal Office for Migration and Refugees reported that majority of returnees enrolled in these programs did not reoffend or attempt to radicalise others. The United States has repatriated a smaller number, but has prosecuted returnees under federal terrorism legislation, ensuring that justice is served while maintaining national security. The evidence is clear. None of these countries has experienced catastrophic results predicted by the affirmative. The catastrophic results have been reached. A positive outcome has been reached. On the contrary, monitored repatriation has allowed these nations to manage risks proactively, protect children, and neutralise potential threats before they even emerge. If our allies can execute these programs effectively, why can't Australia? This inaction signals weakness and a failure to uphold both security and international obligations. So, Mr. Chairman, ladies and gentlemen, in conclusion, the choice before us is not between risk and no risk, it is between manageable risk and uncontrollable danger. By repatriating these women and children, we are not showing leniency, we are showing strategy. The affirmative wants you to believe that abandonment equals safety. In reality, abandonment equals escalation. It is not surrender, it is control. And above all, it is how Australia protects its people and its future. Thank you.
I call upon the third affirmative speaker, James Groom.
Good evening, Mr. Chairman, ladies and gentlemen. The topic for tonight's debate is that Australia should not allow the repatriation of ISIS brides and their children. We, the affirmative team, believe this statement to be undeniably true. Before I begin my summary of our team's case, I would like to point out some flaws in the opposing team's argument. The first negative speaker has tried to tell you that the children in these camps will be exposed to ideologies that are dangerous and harmful, and that rather we should separate the children and allow them into the country while keeping their mothers there. He briefly mentioned it in his speech that we could separate the children from their mothers. While the topic clearly states, as we've pointed out many times, that it includes both the mothers and their children, and that they should not be separated for the case of this debate, or for the purposes of this debate. The first negative speaker has also tried to tell you that these children are citizens of Australia and should be treated as such and should be held with regard as any other Australian citizen would. While the children are Australian citizens, they as children remain property of their parents, and as the topic states, they cannot be separated. Additionally, while the situation the children endure is unfortunate, the government must not analyse the cost and time associated with their repatriation in isolation, but rather combined with that of the mothers as well, as is clearly stated in the topic originally. The first negative speaker has also tried to tell you that as Australian citizens, they should be tried under Australian laws. While ideally this would be the case, the cost to safely remove these people from dangerous sites, as well as the cost and time needed to trial them, combined with the risks posed by allowing them into the country, is not a risk that we would argue is worth taking for the government. The second negative speaker has tried to tell you that the poor conditions of the displacement camps mean we shouldn't allow ISIS brides back into Australia. While we don't deny that the conditions are terrible, this is an appeal to emotion, ignoring the fact that this is the consequence of most of these women's active decision. The Australian government cannot and should not put the needs of 30 women and their children above the 27 million Australian citizens that would be put at risk, as our first speaker has already spoken about, and our second speaker has explained. Compassion does not require recklessness, and Australia can find other solutions to provide for these people, such as aid, NGOs, and regional rehabilitation programs. Repatriation is not the sole answer. The second negative speaker has also tried to argue these women are held in terrible camps where radical ideas are common, and that bringing them home allows them to be de-radicalized. This is a hypothetical situation that cannot be necessarily proven, and we would argue on the contrary that within these camps the ideas are confined, and in Australia they can spread among the general populace. Radicals of this nature, we would argue, are favourable for the Australian government to be overseas rather than within our borders and among our population. The second negative speaker has also tried to tell you that it is irresponsible to allow them to stay in their camps, and our allies would prefer we allow them to leave. This is countered by our second speaker, who previously mentioned that one of our closest allies, the United Kingdom, has already acted in the same way. We would argue that we are more in line with our oldest ally to deny their repatriation than to allow them back into Australia. The second negative speaker has also tried to tell you that bringing them home allows them to be tried under Australian law. While we agree that it is possible to try them, our previous examples of Australian cases, as demonstrated by our second speaker, shows that typically they are not tried or given proper punishments for their crimes. The second negative speaker also used examples in American, French, and German courts, not Australian ones, and they have no confirmation that a similar process would be applied in Australian courts, which is countered by our second example that shows that it wasn't. Now to summarise my team's case. Our first speaker talked about the risk that allowing these former citizens back into the country has to Australian society. She spoke about the potential that these migrants have to still be harbouring ISIS ideals and values, an organisation that promotes jihad martyrdom, the rejection of authority, and state and allegiance to ISIS leadership. She spoke about how these values, as well as the violent nature of the group, poses a risk for Australian citizens and society, with no way of ensuring that these women do not retain their extremist beliefs. She spoke about how the women involved willingly participate, and despite the indoctrination that may have occurred, they still carry these dangerous beliefs and how it is not a risk worth taking. She spoke about how many may speak about these women as victims, despite the fact that they willingly travel abroad, aid those committing acts of terror, and in some cases participate in them themselves. She referenced how about 40% of ISIS brides work as patrol officers, fighters, or prison guards. She also spoke about the resources that would be needed to properly police and surveil these women who pose an increased risk to Australia's safety. Secondly, she spoke about how allowing these women into the country may show priority over other, less dangerous migrants who would like to legally enter Australia. She spoke about the large number of migrants living in detention centres and the favouritism that might be showed if the government allowed the entry of these women into the country over others. She spoke about how it shows the misaligned values of the government and the significant backlash that may ensue. She spoke about the message it sends to other countries and the hypocrisy it would demonstrate. She spoke about how the division and doubt in the government had already been noted in a case concerning Syrian citizens and how the ISIS connection would only worsen this. Our second speaker talked to you about another message that this action would send regarding Australians, that they are free to join these groups and return without any consequences. She spoke again about how the conscious and purposeful decision to leave the safety of Australia to go into a war zone in order to fight for ISIS ideals, often committing terrible crimes in the process. She spoke about how even though ISIS may have suffered setbacks recently, the movement is not dead, and how the women would even possibly their children who are returning, may retain pro-ISIS sentiment, and in the event, and could be utilised by a future ISIS resurgence. She spoke about how the unfortunate circumstances of the women and their children should not be analysed in isolation, but rather contextualised and compared to the serious harm to others that they have assisted in causing. She spoke about how, in order to prevent the acceptance and support of terrorist organisations in Australia, the government needs to take a strong and unified stance against terrorist interference, in other forms too, but particularly with the ISIS brides. Finally, she spoke again about the message this will send to other nations of the world in the fight against terrorism. Will Australia be seen as a country that is lenient and allowing of terrorists and their ideals, or will we take firm action against those who wish to destroy us? She spoke about this lenience and how this could strain international relationships, damaging the nation's reputation in the process. In conclusion, Mr. Chairman, ladies and gentlemen, we the affirmative team strongly believe that the Australian government should not permit the repatriation of ISIS brides and their children due to their connection to violence, terrorism, and their anti-Australian values, but also the message it sends to Australian citizens, terrorists, and other nations. Thank you.
I call upon the third negative speaker, Ryan George.
Good evening, Mr. Chairman, ladies and gentlemen. The topic for our debate is that Australia should not allow the repatriation of ISIS brides and their children. We, the negative team, resolutely believe the statement is false. As the third negative speaker, I will rebut the arguments brought by the affirmative team before summarising our own case. Now to my rebuttal. The first affirmative speaker has argued that the women chose to join ISIS and should face the consequences. We agree these women made the choice, and they are damaging choices. However, citizenship comes with responsibility on both sides. If we abandon citizens abroad, we are undermining the very principle of the rule of law. Justice means prosecution under our own system, not leaving people in indefinite limbo with no trial. Australia has the laws, which we have already discussed, to deal with those guilty of crimes. Refusing repatriation is not justice, it is evasion. True accountability happens at home. Studies by the International Centre for the Study of Radicalisation also reveal that many women joined ISIS under manipulation, coercion, or false promises. Some were even groomed online as teenagers. Repatriation, I would like to stress, also does not mean absolution. It means assessment. Those who are guilty can be prosecuted. Those who were manipulated can undergo rehabilitation. Treating all women as irredeemable denies justice. The opposition have also suggested that Australia lacked the resources to rehabilitate them. However, de-radicalisation programs are already being run through ASIO, the AFP, and numerous community organisations. These programs have been used with returnees from other conflicts and had success in reintegration. Claiming we lack resources ignores the fact that these structures already exist and can be expanded. More importantly, doing nothing leaves children to grow up radicalised, a much greater burden in the long run. Additionally, legal frameworks already exist, such as the Counter-Terrorism Amendment to the Criminal Code Act of 1995, negating some of the legal burden. Beyond this, as I will cover, there is a genuine obligation to do so in international humanitarian law. They've also argued that repatriation sends the wrong message, that terrorism is excused. This is untrue. Repatriation is not excusing terrorism. It is about managing it responsibly. Bringing them home allows prosecutions, investigations, and rehabilitation. Abandonment, however, sends a message that Australia doesn't uphold its own values or its international commitments. Prosecuting wrongdoers here, under our justice system, makes it clear that we do not tolerate terrorism. This is the strongest message we can send. Additionally, this is in no way a metaphorical slap in the face to genuine immigrants. It is about delivering justice and rehabilitating Australian citizens, and it does not impede the process of legal immigration. This argument also ignores the notion that a country has greater responsibility to its citizens as compared to prospective migrants under its constitution. The second affirmative speaker has spoken to you about the possibility of future attacks. We would like to say that the risk of future violence is precisely why repatriation is necessary. Here, Australian authorities can investigate, prosecute, and monitor. In the camps, we have no control, no intelligence, and no prevention. A managed risk at home is far safer than an unmanaged threat abroad. They have also argued that it is a national security threat. However, as we have repeatedly said, if they are remaining in these Syrian camps, there is no oversight, no intelligence, and no ability to intervene. ASIO itself has said in its reports that the risk of unmanaged radicalisation overseas is greater than the process of controlled return at home. The second affirmative speaker also used a single study to suggest that we can never be assured of safe reintegration. However, in the US, no instances of recidivism have been observed, and 2021 Germany-based studies indicated that the overwhelming majority of returnees did not re-offend or radicalise. Regardless, there is a real legal obligation, affirmed by several UN Security Council resolutions, for Australia to repatriate, and one woman's case is insufficient to establish a legal precedent. And they have also argued that repatriation endangers international partnerships with key allies like the UK and the US. Interestingly, this fails to account for US repatriation or their adoption of several resolutions as key Security Council members. They have also lent heavily upon the anecdotal evidence, principally of one specific woman, while failing to acknowledge broader trends in the numerous cross-sectional reports and studies that we have cited. The third affirmative speaker has tried to suggest that our first speaker broke the topic rules in suggesting repatriation of children only. In reality, he never did this. He told you that we should repatriate the women and the children, and we should then separate them under Australian jurisdiction, an effective step in ensuring de-radicalisation as part of reintegration programs. Now to my summary. Our first speaker's first point was that repatriation is the only way to ensure justice and accountability. He stressed the non-involvement of concerned children and Australia's moral responsibility. He also informed you that while some of the brides may have rendered ISIS support in some capacity, the only way, established by decades of legal precedent and long enshrined principles of international humanitarian law and upheld by 4 UN Security Council resolutions, 1373, 2178, 2368 and 2396, to hold them accountable is under Australian law. Expounding on this, he detailed Australia's strong counter-terrorism legislation, which will allow prosecution and real justice, rather than leaving the question of guilt and innocence unresolved. I repeat, this is not leniency, not forgiveness, not condemnation. It is accountability and compliance with international law. He also stressed that the persons in question are Australian citizens, with inalienable rights under the Australian Constitution, including to consular and other assistance. Noting the precedent set with responses to other Australian citizens under exceptional circumstances, he emphasised that treating these women and children differently is to abandon the very principle of equal citizenship. Again, he also discussed that repatriation does not mean excusal of past actions. However, it does mean foregoing abandonment and ensuring due process. Our second speaker, Anya, spoke to you about the dangerous conditions in many detention camps, such as Al-Hol and Rol. These have been described as pressure cookers for extremism, and as recently as July 2025, the International Centre for Counter-Terrorism reported that the contingent of wives, children and relatives at these camps are a key focus of ISIS propaganda operations. She also cited Human Rights Watch and the UN's own reporting, describing the squalid living conditions in these camps, perpetuation of physical and sexual violence, and a lack of education, which all increase susceptibility to radicalisation. She then suggested the alternative, humane treatment under Australian jurisdiction. Instead of allowing radicalisation to fester unmonitored and conveniently ignoring the real risks posed by rebuilding ISIS in Syria, the alternative allows robust Australian organisations like ASIO and the AFP to conduct surveillance, management and de-radicalisation, truly tackling the question of security. She went on to cover the international precedent for such actions. Germany, France and the United States have all repatriated citizens from these conflict zones, including women and children affiliated with ISIS, under rigorous legal and security oversight and with careful rehabilitation programs, combining psychological intervention, education and social reintegration efforts. These countries have seen great success. As I said, no recidivism has been reported in the US, while 2021 German studies suggest that the overwhelming majority of returnees did not reoffend or re-radicalise. Australia, therefore, must cease signalling lethargy and weakness and commit to upholding the moral, legal and judicial standards set by its peers across the world and the UN Security Council. As Matthew Rycroft, UK Mission Ambassador to the UN at the Security Council Open Debate on Children and Armed Conflict once said, "How a society treats its most vulnerable is always the measure of its humanity." This is the decision now facing Australia. And the right answer, we believe, Mr. Chairman, ladies and gentlemen, is to repatriate ISIS brides and their children, eschewing complacency for vigilance, convenient disinterest for genuine justice, and abandonment for reclaimed futures. Thank you.